Dan Donnellon with your Business Litigation Update. In this segment, I'm joined by Scot Ganow of our Dayton office, whose expertise is in data security, information privacy, and social media. Scott, I recently did a business litigation update on 2014 being the 10th anniversary of the coining of the phrase social media and how social media has bled into discovery in civil litigation. There's another area that's on the rise when it comes to discovery from mobile devices. A lot of times people believe that their texts and their emails are automatically erased from their phone if they delete them. But in the world of business litigation involving corporations, questions are starting to arise as to what is discoverable from an employee's mobile device. What are you seeing in your area of practice in that regard?
Absolutely. With information privacy in the corporate space, this has been an issue for several years. As the line between your work life and your personal life tend to blur, with employees wanting more convenience, access to information, to work and have personal information on one device, companies are having to develop policies to deal with mobile devices, such as bring your own device policies or BYOD policies, as well as telecommuting policies and things like that. It's extremely important that these companies, from a compliance perspective, clearly establish what expectation of privacy these employees have, but also what are acceptable uses of those devices, as they are effectively tied to the company network and representing the company in their use of those personal devices. So these policies are extremely important to clearly set expectations and have employees comply, but they also suggest a level of diligence on the corporation to manage that information and control it responsibly.
So it would be wise in business litigation, opposing a corporation, to be asking questions about their bring your own device policy and how they follow who owns the data on the personal devices. The Supreme Court's recently taking this issue up as well with respect to what is your expectation of privacy on your mobile device. Can you comment on that?
Absolutely. For years now, decades actually, we've had the standard of a reasonable expectation of privacy. Simply put, if you do something or say something in the presence of others, you don't have a reasonable expectation of privacy over that information. It's been around for decades. But now, in the digital age, where in a previous case, Supreme Court Justice stated, everything we do anymore, even the most mundane of tasks, happens online or on a device. The standard may be changing, and the court's currently considering this both in a civil and a criminal context as to whether we have a reasonable expectation of privacy over our phone related data, not just the text information, phone call information, browsing habits, all those types of things. Even though they interact with third parties, is the standard going to shift, and should it shift in view of the changes in society with respect to the internet?
So with respect to companies that are or may be involved in litigation from a business standpoint, it's important to not only implement your policies and have those policies in place, but it's important in consideration for who owns that data when it comes to discovery issues. With your Business Litigation Update, I'm Dan Donnellon, joined by Scot Ganow.